Good afternoon. I am calling to order our regularly scheduled meeting of the Intergovernmental Relations Committee. My name is Elizabeth Glidden. I'm the chair of this committee, and I'm joined today by Councilmember Cano and Councilmember Andrew Johnson, and we expect Council President Barbara Johnson to walk in momentarily. We have 3 discussion items on our agenda for today. The first item is a continuation of our discussion of the 2018 legislative policy positions. And Ms. Bergman, if you want to introduce where we are at.
Yes, thank you, Madam Chair and Council members. Sasha Bergman with the IGR Department. I'm pleased to be here today with staff from various departments to present 4 items that came up through our policy liaison team process. We anticipate no committee action on these items today, but that these would be for potential consideration in the 2018 legislative policy position document draft that we anticipate will be considered by this committee in November. For today's presentation, we did submit an attachment to the RCA, which has a collection of worksheets with information. It looks like this about each of the proposals, and that includes information about the staff contacts for each of those items. And we also asked each presenter today to create a few slides, and we combined them onto one slide deck for efficiency, so we'll just start running through that in a moment. But before we get started, I want to just give a huge thank you to our policy liaison team members. As you know, this interdepartmental team has been working over the last several weeks to present these items, to vet them, research them, answer questions, and it's been a great pleasure to work with them, and we really appreciate all of their work. I also want to give a special thank you to the staff who contributed to the proposals that are before you today, and some others that are not before you today, but that were presented through the policy liaison team process. We know it's a lot of time and effort, and we really appreciate their partnership on these items. At this point, I will turn it over to the City Attorney's Office, who will present the first 2 proposals before you, and then Public Works will follow him, and then Finance and CPED Housing.
Thank you very much.
Madam Chair, council members, my name is Chris Dixon, for those of you who have not met me. I'm a supervisor with our criminal division at the City Attorney's Office, and we have 2 quick presentations to present to you this morning. The first, I wish I had a shorter title for you, but we're talking enhanced driving after revocation based upon an impaired driving offense license revocation. What we are asking for the legislature is to create a higher penalty for driving during the revocation period of an impaired driving conviction. And essentially what we're talking about is creating a gross misdemeanor driving after revocation, which we call DAR, this type of offense if the revocation is based on an impaired driving offense and the individual violates during the hard revocation period. Now, I'm going to explain what a hard revocation period is in a moment. But why is this important? Well, first and foremost, it's to put some teeth into the administrative penalties associated with DWIs. For those of you who don't know, in Hennepin County, if you are suspended or your license is revoked for a DWI, let's say it's your first DWI and it's a 30-day period, if you get a DAR during that 30-day period, in Hennepin County, you could simply go on to the courthouse and pay a fine. It's a payable misdemeanor. So that's all. That's the penalty. Now, there is an exception in Hennepin County. If the prosecutor's office files a formal complaint, we can turn that into a misdemeanor. But based on the many, many cases we get and the backlog to the courts, that's really not a reasonable option to do. And also, we have a safety reason in mind. This is to encourage the use of the ignition interlock, which would cut those revocation periods down. And I'll show you why in one moment. This is probably going to be a little difficult for you to see, and we can always show you this slide later, but this is from the Department of Motor Vehicles. These are outlining the hard revocation periods for DWIs. If you get a first DWI, your license and your blood alcohol content is between 0.08 and 0.16. Your license revocation period would be 30 days. Now, you can get a limited permit to drive after 15 days, but that's it, a 30-day revocation. If you're double the legal limit, that revocation period jumps to 1 year. If you refuse to give a test, that revocation period is 90 days. However, you're also eligible for a limited license after 15 days. And as you can see, the license revocation periods increase dramatically over how many DWIs you get. A second and 10 is a year. If you're double the legal limit, it's 2 years. A third and 10 with 1 over 10 or 2 over 10, it's the same. So the possibilities here are for extended revocations. However, and maybe you can see that red outline in the slide above, it says all of the above have the option of being reinstated with the installation of ignition interlock for the withdrawal period if you're 18 years or older. So all of these revocation periods, even for someone with 2 DWIs on the record, can be limited down to whenever you get that ignition interlock. What does this do? This encourages people who really are serious about their driving and serious about getting sober to get their license back. It's safer for our roads, and it's safer for our pedestrians. And as you can also see, this is not something if you get a 3rd or a 4th or a 5th DWI, that's already a gross misdemeanor. It's called driving inimical to public safety. So what we're talking about is during that hard revocation period, that 30 days or that 1-year period without the ignition interlock, of making that particular period a gross misdemeanor to give some added teeth to this particular statute. However, saying that, I want to be very clear what is not affected. We do not advocate an enhanced driving period for driving after suspension or cancellation. In other words, for those people who cannot pay their fines and fees, and that's the reason they're suspended, we don't ask for this gross misdemeanor. In fact, our office has always held the position that we encourage people to be placed in a diversion program so that they can get their license back and drive legally. We don't think this is an equity issue. We think this is a safety issue. And in order to separate those two, we want to make that clear, that we are not advocating higher penalties for suspension for fines and fees. Also, this would not apply if you're eligible for reinstatement after that hard revocation period, what we would call the soft revocation period. In other words, if you were suspended for 30 days for your license, but you just didn't get it back because, for instance, you couldn't pay the reinstatement costs, which can be expensive, that also would not get the increased penalty. That would be handled the way we've always handled it. And we're only talking impaired driving offenses. If you get a revocation for something else, such as no insurance or hit and run, that would not be covered as well. The only enhanced penalty would be for driving during the revocation period of an impaired driving conviction. I will go through both of these if you have questions at the end or questions now.
I would actually like
Yeah,
to ask some questions if you want to go back on this item.
certainly.
So, on the enhanced driving after revocation based on impaired driving offense license revocation.
Yes.
So, just not understanding how the system works. Can you give me some more information about what is involved in getting an ignition interlock? Do you, what does it take to do that? And in terms of time and trying to get that installed, and then is there a cost to the individual for utilizing that option?
There is a cost. There are, as I understand it, there are 2 companies that the state of Minnesota currently, there might only be one. I'll have to get the exact details of that to you at a later time if that's appropriate, Madam Chair. But I do know that there is a couple of companies, I believe it might only be one, that the state has contracted with so that it runs to the DMV. There is a cost associated with it.
What's the cost?
You know, I do not know the answer to that. And I can
So
find
that might
for
be
you.
some good follow-up, is just what's involved in getting this installed and what's the cost? Because I'm just trying to understand, because you've said that's an alternative that ends up being, you know, something workable. And you also told us there wasn't an equity implication. And I'm trying to understand, what does it take for you to utilize the option of installation of an ignition interlock? Again, just because I don't understand that system. And then I'm curious, what do we know about kind of the violations that might happen after a first incident, kind of the incidence of this versus second incident and those kinds of things? Again, I'm making an assumption that if you are someone who has had more than one instance of driving under the influence, that this is, you know, exponentially more serious situation than a one-time offender who, whatever. So I'm just trying to understand, what does the data tell us about kind of the frequency of driving during this 30-day period you might get if you have a first incident on record?
Okay, Madam Chair, I'll try to address your get back to your first question. First, I would like to say the equity issue I was talking about necessarily wasn't the cost issue. It was who gets impaired driving offenses. That is one of those offenses, one of the few actually, that affects all realms of society, regardless of socioeconomic status.
Absolutely. But I guess the thing I'm pointing out is that the part of the issue is about how you're able to solve it.
Correct.
And
I understand
how
that, certainly.
Who is better able to solve it?
Yes. The answer would probably be, I'm sure that there is a price point to that, and I can get that information.
I'd like to
back
follow up on that.
So. Absolutely. In regards to your second question, in terms of the data we've looked at, now this is going to be anecdotal. I don't know of any studies presently for that's done by the state, although I bet the Department of Motor Vehicles would have something, and I will certainly check about who offends within that 30-day period and who offends outside of that 30-day period. The anecdotal evidence we have, though, is people offend and offend and offend and offend again and again, starting during the revocation period. And that 30-day period is one, it really depends on when you're caught.
So I guess the point I'm trying to make is kind of what do we understand about offenders who are stopped because they have driven during the time when their license is revoked, and just what do we understand about that picture? And then I guess my other, just more of a policy question to you is, why is this proposal for all incidents as opposed to having the gross apply when you have a second incident on record, or again where it seems like things are escalating? So what was the analysis that you used to decide that you should ask for a gross on the first time as opposed to a second time when someone's behavior is more clearly escalating?
Madam Chair, the answer to that is we're not asking for an enhanced penalty based on second or third or fourth or fifth time. That actually is another proposal I know in front of the legislature. What we're asking for only is an enhanced penalty if you get a new driving after revocation during the time your license was revoked for that DWI.
I understand that. I'm saying, why did you ask for the gross to apply after the first incident as opposed to targeting the gross to if you have a driving after revocation after you have a second incident, or again where your behavior is escalating?
Oh, so all during the revocation period, you're saying? Like a first would be a misdemeanor during the revocation period, a second would be a gross misdemeanor during the revocation period? I guess I... So
you have first incident on record. So it seems like we're maybe not communicating the best, and so I don't want to, this is not like putting you
That's all right.
through some sort of dragnet here of questions. I am honestly interested in why was the policy decision to ask for a law change that would start to apply that you're going to get a gross after the first incident on record revocation experience, as opposed to targeting getting that gross after a second incident where you've revoked after you've had a second driving under the influence offense?
I guess the answer, Madam Chair, is we hadn't thought that far ahead. The two analyses we had made were, we didn't want it to affect somebody who got a lot of driving after revocations because they couldn't pay their fines and fees. Our analysis came down to simply, we wanted a higher penalty if you got that revocation because of an impaired driving conviction. And we didn't make a distinction between a first impaired driving conviction or a second impaired driving conviction. To us, an impaired driving conviction is the serious offense, regardless of if it's your first or second or third. We wanted to increase the penalty immediately to get your attention that you can't drive. One of the penalties of driving under the influence is you lose your license. And if you drive during that particular period, there should be an enhanced penalty, whether it's your first or second or third. The difference is we didn't want it to affect, okay, you got suspended for your license being revoked, or you were eligible to get your license back. But in terms of what level of DWI would trigger that, we just thought that since driving under the influence is such a serious crime, it should affect all.
Okay. I wanted to kind of hear directly from you about that, and also maybe your answer to about what's the picture look like of individuals stopped. I mean, I think this is a very serious offense. I mean, anyway, so I'm not trying to indicate that. We have a question from Council President Johnson.
Thank you, Madam Chair. Why would we not include driving after being revoked for insurance violations or hit and run?
Councilmember Johnson, at this point in time, we had just made the analysis that driving under the influence is the thing we wanted to concentrate on the most. If you're asking me if I would personally be opposed to that, I would have to give it some more thought. But I will be honest, there are a lot of people out there who would drive with insurance if they could, and that becomes more of a monetary issue in some circumstances. And with the pulse of the legislature, I thought we wanted to start with those offenses that we could all agree on.
Interesting. I tell you, my constituents would say that's really important because they're subject to, the people that drive without insurance that run into their houses, run into their cars. It happens all the time, and it's a big hot button. So I really would like to think about that, adding that. So I won't do it today, but I want to think
Right.
about
If I could
So
briefly,
if I could just say something too, I think that's an important thing. I was in an accident not too
Yeah.
many years ago, actually, with an uninsured driver. And I will say sort of the thing that is benefit is luckily I had insurance. So other than paying for my deductible, I was able to be covered. I just want us also to kind of think that we have an existing position on our state legislative agenda that is about trying to ensure kind of all residents are able to get driver's licenses. And so a lot of these issues end up being kind of really challenging with who has access to kind of what systems and things like that. So,
and Madam Chair, Councilmember Johnson, there is actually a gross misdemeanor insurance violation if you have third and 10.
if you have what?
A third violation within 10 years.
Okay, good to hear.
Ms. Lesh?
What about hit and run?
There is not an enhanced violation for hit and run, but there are enhanced violations if, for instance, there was damage to an individual, personal injury, something of that nature.
Madam Chair and Council President, I just wanted to interject that the proposal that Chris is bringing today would be part of a holistic comprehensive package. So it shouldn't be viewed just in isolation. We have some other components and we're considering adding this to a package that we worked on last year. And one of the items that was in last year's package is kind of looking at some of those insurance issues and the collision issues where we're suggesting that a box be reinstated on a citation that used to be there, and we don't know why it was removed by the state. But if that box is checked by an officer responding to the scene of a collision and someone was driving without proof of insurance or without a valid license, that would be a court-required appearance.
Okay.
It wouldn't be an enhanced penalty up to a gross, but that would be a court-required appearance. And we're trying to get at the issue that you're noting, that
Okay.
there needs to be some accountability for people who have their property damaged or that they're injured when someone's driving without a valid license or driving without insurance.
Sure.
They need to have their day in court.
They'll have to go to court.
Yeah.
Okay, it won't be one of the payables.
Exactly. We're trying to
Okay.
get at the payables issue multiple ways.
Thank
Yeah.
you.
Thank you.
I'm not seeing other questions, so if you'd like to go on to presentation 2.
Thank you, Madam Chair. The second, again, is probably our most serious issue that is facing our office, and I believe victims across the state, and that is to fix the restitution and expungement hearings in light of a case that came out called State versus Willis. This is a Supreme Court case that happened in 2017, and essentially what happened in State versus Willis is the Minnesota Supreme Court stated that the rules of evidence will now apply to restitution hearings because they are not specifically enumerated in the list of miscellaneous proceedings where the rules do not apply. And that, for anybody's edification, is Rule 1101B3. Now, previously to 2017, courts had interpreted that a restitution hearing was part of a sentencing hearing. And a sentencing hearing is specifically listed under 1101B as a hearing that the rules of evidence do not apply. Based on the court's interpretation of this rule, we also think now that anything not listed in 1101B3 specifically, such as expungement hearings, would mean that the rules of evidence are going to apply. Now, why is it important in the restitution context? I think the person who would put it best in her dissent of this opinion in Willis was Justice McKeag. Now, many of you may know Justice McKeag. She was formerly a Hennepin County District Judge. And I'll also say that she is the justice on the current Supreme Court who has the most district court trial experience. And she said two things in her dissent. Accordingly, I respectfully dissent from the majority's decision, which misinterprets Rule 1101B in a manner that will prove burdensome to parties, victims, and district courts. Parties in district courts will be forced to stretch their resources even thinner to accommodate restitution trials. And victims who have often endured traumatic violence at the hands of a defendant will be required to face their aggressors to testify not only at a trial, but again at a restitution trial. What are the practical considerations? Essentially, a great deal of the state's evidence that we currently use in these restitution hearings will now be inadmissible. And I'm going to give you two examples that I think enunciate the point. First, and the one that Justice McCaig mentioned, victim does not wish to face their accuser again and wishes to submit a claim by affidavit that will now be forced to come to court. Let's say we have a victim of a rape who testifies at a trial against her rapist. He is convicted at court. As a consequence of the traumatic experience, she gets counseling. That is something that normally would be covered under the restitution statute that the accused would have to pay. However, now that victim is going to have to come to court again to testify about her damages. Simply submitting an affidavit would be insufficient. That would be hearsay, and she would be forced to come to court. The second example that, frankly, my office faces on a weekly basis is a victim who comes to testify will be precluded from introducing an estimate from a repair company to show their damages. Such a document is hearsay, and therefore would be inadmissible. The classic example is someone's car is damaged. They want to get an estimate from a garage that, oh, this is going to cost me $600 to repair. She tries to bring that into court and produce her estimate. That estimate, of course, is hearsay. It's an out-of-court statement from that mechanic. In order to prove that particular issue, we would have to call that mechanic. And I got to say, Madam Chair and members of the council, that would be incredibly difficult to do. And frankly, I do not think we would get many people to show up. Why is this important in the expungement context? Well, it's important not only for the state, but it would be also important for the petitioner. For the state, when someone applies for an expungement, the state would no longer be able to introduce a copy of the original police report to argue against the expungement of a criminal record. That evidence would be hearsay. Let me give you an example. Someone commits a robbery. It's 20 years old. That person applies for an expungement. Typically, what our office or the Hennepin County Attorney's Office would do, since finding that victim of a 20-year-old robbery would be almost impossible, or they could have died or moved on, we would produce the police report to say, you know, Your Honor, this is why this case is so serious and this case should not be expunged. That is now hearsay. That would not be admissible. However, it's equally important for the petitioner because petitioners would be unable to introduce letters of support or letters from prospective employers to show adverse impact, which is one of the things they need to prove to get the expungement. And that's what's necessary for their expungement. Again, that would be hearsay. They would have to actually produce those people who are supportive or produce an employer to say, I did not give them the job because of that letter. And to produce such a person, an employer who didn't offer you a job, again, I don't think, frankly, they would be able to do that. And that makes it very difficult for them as well. And for those two reasons, this is an incredibly important issue now in light of State versus Willis.
Thank you. And, you got the proposed fix.
This is an easy slide. Yes, the proposed fix is essentially adding one sentence to both the expungement and the restitution language. This is the statement right out of 1101B3. The rules of evidence other than those with respect to privileges do not apply in these types of hearings.
All right. Thank you very much. Appreciate it. Not seeing other questions on that.
I'm sure. Thank you.
All right. Thank you.
Good afternoon, Chair Glidden and members of the committee. I'm Robyn Hutchison. I'm the Director of Public Works. I'm presenting today on the topic of addressing a new policy moving forward to prepare for changing transportation technologies. Minneapolis should be requesting that the state examine our local needs when considering any modifications to state legislation to accommodate automated and connected vehicles. Any state legislation considered should ensure that our local traffic laws are followed and that performance and safety information is freely shared. Committees that have been formed or will be formed should include representation from the city of Minneapolis and other local units of government. And we should be working together to influence federal policy. I'm going to talk for just a few moments on why we in Public Works feel this is important and important to address now. We're all very familiar with driverless cars at this point, and I joked in a meeting yesterday that I try to make it till 11 a.m. every day before I say the words autonomous vehicles. This is a very timely topic
MnDOT is out ahead right now. They are planning to test self-driving buses this winter. They formed a group to examine state laws called the State Transportation Innovation Council, on which I participate, and I was very happy to have been invited. Met Council is monitoring this. The National League of Cities, the American Architectural Foundation, National Association of City Transportation Officials have all put out guides and helping information for local governments to help to get ahead of this. Other cities, including St. Louis Park and Bloomington, are starting to plan for automated vehicles. Nationally, there are no fewer than 10 pilot projects, either on the ground or in development on the streets with autonomous vehicles. For our part in the city, we are speeding up. From a staff perspective, we're engaged in the Transportation for America Smart Cities Collaborative that is helping our understanding. John Wirchis is joining me today. He represents us on that. We learn from other cities, and we are understanding more and more what we need to do from a technical perspective to prepare. From a policy perspective, there are a number of things that I feel we should be doing and that you are already doing as policymakers. One is you've requested a study session, and I'm looking at dates for some technical experts to help you and us understand better. In addition, we are tracking federal policy, which is part of how we have assembled this list of important items to consider in the state policy. So I'll turn now to some of what was included in that federal policy that has us thinking about what's most important for us to be asking the state for at this time. This is very much about preparation. How do we work together collaboratively with the state to prepare? Among many things, what that federal legislation proposes, and it's on the floor now, is that it's a bundling of state and local government. So everywhere in that language it says state and local government shall, should, shall. It's together. So it pins us to the state. And we should be very articulate about what's most important to us as the state is thinking about the development of their legislative policy on autonomous vehicles and transportation technologies, perhaps even those we haven't even thought of yet. So there's a few really important things here. First, the federal legislation preempts state and local governments from enacting our own local laws on our streets with respect to traffic control. We obviously disagree with that, and we feel that we should be stating very clearly for the state that local laws should be followed by driver and driverless vehicles. The second thing the federal legislation does, as a heads up for us, is that car manufacturers will not be required to supply performance data. And as the stewards of our transportation system, and as a city that has doubled down on our commitment to safety, we need to both have access to and be able to utilize the data that is being produced from private companies who will be using our rights of way to advance their technology. And then the last third point is about our seat at the table and participation. Nowhere in the federal legislation does it talk about local government, except to say we're sort of pinned together with state and local government. We feel it's important that we have a seat at the table. And I am very supportive and trusting of our state government that they will give us that when we ask them for it. So this policy is articulate about our participation in the development of any state legislation or policy related to autonomous vehicles. It's important we talk about this now. Why now? This Lyft generated this image. Company Lyft is preparing for autonomous vehicles. This is just any street in any city USA, but probably this is a city right-of-way. So this is one illustration of how quickly this is moving, that both private and public entities are starting to plan ahead, make their plans for a driverless future. This technology has the potential to significantly increase traffic congestion, vehicle miles traveled, and climate pollution, but it also has the potential to have numerous benefits for us if we get the policy right from the beginning. So it's starting to move very quickly. And I would hope that you would give strong consideration for including this preparatory policy in the state conversations upcoming. Thank you, and I'm here for any questions.
All right, thank you. I don't see any questions. I will say I think this is just an important kind of first stepping our toe in the water, essentially, so that we're kind of positioned to be more specific as things start moving more in this arena. So thank you very much.
Thank you.
Oh, Councilmember Cano does have a question.
Thank you, Madam Chair. I'm just sort of still noodling on this driverless technology issue, and just curious, are there any cities currently that have this operating vehicle in use?
There are a few pilots out there. Our best example is in Pittsburgh, where Uber and the city of Pittsburgh have partnered to put autonomous vehicles on the street. There is still a human being in the Uber car, but it is an autonomous vehicle. They're random. I was in Pittsburgh for a meeting on this very topic, and I Ubered everywhere because I really wanted to get into one of the, 3 blocks away, I still called an Uber because I really wanted to get into one of those autonomous vehicles. I never saw one. But they're midway through their pilot right now and providing a lot of information to the rest of us cities that are really curious on how it's going. There's a number of others that are in development. Austin is another city that's leading. They're not in development. Austin is another city that currently has autonomous vehicles running on their streets. They're doing a lot of work around how it works with signals, how it follows traffic control devices, and also producing good results that the rest of us cities can take a look at and use.
And I'll just note, this is a topic that Ms. Hutchison has been a lead, but it really crosses over multiple interests from the whole city enterprise. And I know there has been some look at trying to find a good date for a study session, which I think will be really exciting. I think we've been a little challenged at the end of the year to find the right date for that, but I know that if we don't find one by the end of this year, that they'll be looking for a study session opportunity as first opportunity in the beginning of the year. So, all right.
I just wanted to finish by saying that I'm intrigued by this topic because a lot of the minimum wage conversations that we had a while ago was around automation and will workers be replaced by robots essentially to cut back on costs and adhere to a minimum wage ordinance. And so as I'm looking at this picture and imagining, I'm just curious about the impact of this kind of new transportation method on, the current East African population, which is, highly active in the taxi cab industry, the Latino population, slightly so as well. And in general, just trying to figure out what this would mean for like our workforce and would it displace workers? And so like, if I realize this is not the committee to have that discussion, but I'm just letting you know that this is an interesting topic for me for a lot of reasons. And I'm just curious to know more.
Thank you. And I'll just say, I think your kind of the angle you're entering in with questions kind of just shows the breadth of potential impact and questions and policy that needs to be considered. Councilmember Andrew Johnson had a comment too.
Thank you, Madam Chair. And I wanted to piggyback off of those comments because I know that that's one question a lot of people have about automation. But I also think about all the other ways this is so transformative. Every year, 1.3 million people on Earth die in auto accidents. 37,000 die in auto accidents every year in the United States. And just alone the safety improvements of these vehicles, being able to reduce those deaths, is such a game changer. And then another aspect, when we think about minimum wage and we think about affordability, cars are an extremely expensive commodity to have. And for those of us with the privilege of being able to afford them, it comes at a large cost. And right now we obviously have public transit as a big way to help people get around, but this really opens up the door accessibility-wise in so many ways and helps lower the cost of transit. And actually, I think this will be an important factor in getting us to the point where transit is a right, transportation is a right in our nation, and we can get around and not have to worry about market forces restricting access for individuals. And I also think about the accessibility factors here, how these vehicles will be a complete game changer for those, for instance, with blindness, being able to be driven wherever they need to go very easily and on a moment's notice. And so it's an exciting time, and there's certainly complications from it as well, where we're going to have transformation in the job market, but it opens up a lot of doors to help a lot of people in many different ways. And I think if we're smart, getting ahead of it now and preparing so that we can help folks through the transition so that it's not disruptive to their incomes if their jobs are tied in to transportation is all the more important. And that's why I'm glad that we have this leadership on this topic.
And Councilmember Cano has one additional question or comment.
What car companies are manufacturing these cars? Do you know off the top of your head?
Google cars are out in Austin right now. Google, Ford, GM under development, Volvo being tested. Volvo's leading on the truck side, both passenger vehicles and trucks. John, what am I forgetting? Who am I forgetting? Daimler, BMW, almost everyone. Yeah, there's there's like a group of like pushers, leaders, but the whole market is coming. Yeah.
All right.
He's still talking back there.
Okay.
Thank
so
you.
we have one more presentation, and then we have another topic that I know others are here. Just as you're getting set up, I will just say to kind of go back to a question I posed to Mr. Dixon about how what would be a cost for utilizing Interlock device, and Ms. Siegel responded via email during your presentation. So just thought I would say it here. It looks like you are able to get that installed for a cost of about $85 a month. So I guess you compare that to being able to go where you need to go for work and other things. That seems pretty reasonable. I just thought I would pass that along since we had that here. Thank you.
Thank you. Good afternoon, Madam Chair, members of the committee. My name is Matthew Hendricks, and I work in the city's Development Finance Division. And before I launch into the presentation, I want to acknowledge that most of the work behind the presentation was performed by Mark Winkelhake, who was not able to be here today. And I also want to acknowledge Nikki Newman from the city's attorney's office, who did a lot of work on this as well. So this is a presentation about clarifying the tax increment financing pooling laws. And by way of background, the city's use of TIF is enabled by state law, and so state law also sets limits and governs our use of TIF. And in a practical sense, it's the Office of State Auditor staff who enforce the state law, and they closely monitor the city's TIF districts from the year they're created until the year they're decertified. There is a provision in the state law that allows tax increment that's generated within a district to be used outside the boundaries of that district, and that's typically termed pooling. And in the last 7 years, the city has used pooling to contribute roughly $16.7 million to our Affordable Housing Trust Fund. So the cap on pooling that's set by state law is 35% of tax increment from a redevelopment TIF district. And city staff believes that this is a cumulative test, meaning that in some years we might pool less than 35%, and in other years we might pool more, so long as the cumulative percentage over the life of the district does not exceed 35%. However, under a new interpretation, OSA staff have stated they think the test should be annual, meaning that in no year could more than 35% of the TI from a district be pooled. And this is a problem, and I'll get into that in a little more detail in a couple slides. And the solution to the problem is a simple clarification of the state statute to make it specifically clear that the test is cumulative. So this slide is looking back at the last 7 years and showing the amount of pooled tax increment revenues that were allocated to the Affordable Housing Trust Fund. And you'll see that especially in recent years, a significant portion of our trust fund dollars came from pooled TIF, and the cumulative total is $16.75 million. This slide is slightly more complex. It's looking forward at the next 11 years. And this is a projection of the amount of tax increment that we could allocate to the Affordable Housing Trust Fund. In column 2, those amounts are based on an annual test. So that shows the amount each year that we could designate for affordable housing, and the total is just under 14 million. Column 3 looks at the scenario in which a cumulative test is allowed, and in that column you see that the total over the 11 years that we could allocate to affordable housing is just under 30 million. So the difference is shown in column 4, and you can see there's a substantial difference. Over the next 11 years, roughly $15.8 million would be available for the trust fund if we can get this clarification. And to kind of highlight what that means in terms of impact, so the $15.87 million over 11 years would be applied through the trust fund, and the trust fund has a $25,000 per unit maximum investment. So that means at least 635 more affordable apartment units in the city could receive assistance if this clarification were made. And with that, I'll stand for questions. And also, I want to mention Andrea Brennan from the city's Housing Development and Policy Director is here.
I'm not seeing questions. Can you just refresh me on what prompted this new interpretation by the Office of the State Auditor? Was it a court decision, or just they had a new issue to analyze and ended up having this interpretation?
You know, to be honest, I'm not sure what triggered it. Yeah.
Madam Chair, Sasha Bergman with the IGR Department. I believe there was some new data collection mechanisms or new way that they were seeing the data and seeing that cities were doing this differently across the state.
Okay. All right. All right. I'm not seeing questions. Thank you very much.
Yeah, thank you.
All right. Ms. Bergman.
Madam Chair, that concludes our presentations for today. And we're happy to stand for questions if there are any now or over the next couple of weeks as well.
Okay, so then I will move to receive and file those presentations, and I think at our next meeting is when we'll move to adopt a revised agenda, including this and some other changes. Council President Johnson.
And thank you, Madam Chair. I guess, you know, my pit is potentially a change in state law to allow the city to tow cars that are inoperable. Where is that at?
Madam Chair and Council President, I think we were planning to put that in the draft policy positions with all the other changes, and that would be up for committee discussion, probably on the November 9 meeting.
Thank you.
All right, so all in approval of this receive and file, say aye. Aye. Opposed? And so next we turn to our second discussion item, which is an update on Upper St. Anthony Falls Lock.
Thank you, Madam Chair. And one note before we move on to this, I also just wanted to add to the discussion around the DAR DWI revocation that there also is a program through the state of Minnesota for those who cannot afford ignition interlock. I want to make sure if anyone's watching, if they need help with that, that the Department of Public Safety does have a program that you can apply to receive financial assistance if you can't afford your ignition interlock. So with that, Madam Chair, what we have for you today is an update from a staff direction that the Committee of the Whole and then the Council approved in June, directing the IGR Department along with CPED and the City Attorney's Office and Public Works staff to do some work around the Upper St. Anthony Lock and Dam. So we're back with you today to give you an update on that staff direction. Just by way of review, and also want to mention that Emily Stern from CPED is here, along with Shelley Rowe from the City Attorney's Office. If there are technical questions in their respective wheelhouses, I'll be doing the presentation, but they're here if questions are needed. So the staff direction that the Council approved back in June directed IGR, CPED, City Attorney's Office, and Public Works staff to work with representatives from the Friends of the Lock and Dam, the U.S. Army Corps of Engineers, Minneapolis Park and Rec Board, and other interested parties to examine options for the future of the Upper St. Anthony Falls Lock if the Army Corps of Engineers elects to discontinue the project for its current authorized purposes based on existing and anticipated future conditions. If the U.S. Army Corps of Engineers recommends deauthorization or a change in the purpose, staff should examine different ownership and operational structures that could meet the state constitutional and statutory requirements for the receipt of state bond funds and other public financing support. Madam Chair, as you'll see, the staff direction requested information about various ownership and operation structures that the city could engage in to meet the state constitutional and geo requirements. We did work. The work we did to better understand the Army Corps of Engineers and the congressional disposition process led us to conclude that discussion of ownership models at this time is premature. It's really going to depend a lot on if the Corps does decide to dispose of the property, when that discussion is completed, how the Corps would choose to, how the Corps suggests to Congress to dispose of that property, when Congress would act on that recommendation, and how Congress acts regarding the disposal. So our presentation today will really focus on what to expect regarding the process over the next few years regarding the property. So just by way of review, current status for the St. Anthony Falls, Upper St. Anthony Falls Lock and Dam. It's currently owned by the U.S. Army Corps of Engineers, and the lock was closed to navigation by an act of Congress in 2014. It's important to note that in 2014, while Congress did close the lock to navigation, it did not deauthorize the property. So the property is still in operation for flood mitigation. It would take an additional act of Congress to deauthorize the lock. The Army Corps of Engineers is conducting a disposition study, which allows the Corps to evaluate existing projects that no longer serve their authorized purpose. The objectives of that study are to review existing conditions of the upper and lower St. Anthony Falls locks and dams and lock and dam number 1. So all 3 properties will be studied in the disposition process, and to determine if there is justification to recommend congressional deauthorization. The additional objective of the disposition study will be to determine the appropriate disposition of each of those 3 individual properties. The reason the Corps is undertaking the study now is that the last lockage occurred in 2015, and they have determined that the cost of maintaining these 3 sites is about $1.5 million per year, not including dredging and other major maintenance. So it's a confluence of these factors that's causing the Corps to conduct this study at this point in time. So, Madam Chair, going forward, the point of the disposition study is really to focus on whether federal interest does still exist to retain the property for its authorized purpose based on an evaluation and comparison of the benefits, costs, and impacts, both positive and negative, of continued operation, maintenance, repair, replacement, and rehabilitation, or lack thereof, on the one hand, and of deauthorization and disposal of the associated real estate property on the other hand. If during the disposition study that opportunity exists to modify a project to serve a different water resource development purpose, investigation of such an opportunity may occur if funded in a new feasibility study that is different than a disposition study. So moving forward, what we should be expecting over the next 1.5 years to potentially 2 years. In May of 2017, the Corps did initiate the disposition study of the upper and lower St. Anthony Falls locks, as well as lock and dam number 1. In August, they decided to proceed with the disposition study, and now we're looking at an 18 to 24-month horizon to complete that disposition study. So we should expect results of that study in early to mid 2019 that we would know what the results of that study would be. And then you see here some more detail about what the different benchmarks of the disposition study would be. The first phase has been completed, that decision was made to actually proceed with the study. That occurred in October of 2017. And you see before you a timeline of what we should expect over the next 18 to 24 months. The important pieces, I think, to identify are towards the end of the timeline is when we would expect another action step. The results of the disposition study will be forwarded to the Army Corps of Engineers headquarters in or about May of 2019. The results of that study then are, that recommendation is then forwarded on to Congress. Congress at that point in time has different decisions that they can make. After the completion of the study, Congress will act on the recommendation to deauthorize the project. They may deauthorize at that point in time, at which point the property would move to a GSA process, a General Services Administration process, kind of a long traditional federal process for disposing of unused federal property. Or Congress can intervene at that point in time and interject themselves and put very specific direction on the disposal of the property. And they can put additional requirements and expectations on the future of the property of their own volition. So we have some detail here about what, if they move forward with the GSA process, what that can look like. The GSA process requires that properties that are classified first as excessive property, if they are at that point in time, then there's kind of a waterfall of priorities that the federal government can go through to determine who then has access to that excess property. In that pecking order, the first position would go to other federal agencies. In this situation, we would anticipate another federal agency that would have interest in the property could be the National Park Service. We have heard from the National Park Service, and I'm sure you've heard the news today about increasing costs to fees to use other locations of the National Park Service. They, at this time, are not expressing any interest in potentially owning or operating the Upper St. Anthony Falls lock in the future. They're having budget struggles and other properties that they are already responsible for, so it's not terribly surprising that they're not at this time interested in expanding their portfolio in terms of owning and having total operation responsibility of a property. So the first stop in that waterfall would be another federal agency. If no other federal agency is interested in owning the property, then GSA looks for a public benefit conveyance to potentially HUD for a homelessness conveyance. That is typically, of course, if there's an actual building that could be used to provide housing for homeless residents. A lock and a dam is probably not going to be appropriate for that. So then the next step in that process that GSA would look at would be a negotiated sale to state, local unit of government, or eligible nonprofit organization for public purpose. That's where the city, a nonprofit, the state of Minnesota would plug in at that point in kind of the pecking order of who would have access to the property if the federal government does decide to dispose of it. And then finally, if there was no real kind of local public interest, then the property would move forward to a public sale for a bid or auction. And then additionally, Madam Chair, I would note that the GSA must consider all existing FERC licenses for hydropower when they're making their disposition decisions. At the end of the disposition study process, if Congress does not act to dispose of the property, or if either in the disposition process, the decision is not to dispose of the property, not dispose of the property fully, or if Congress does not move to dispose of the property, then there's another fork in the process that would be a potential feasibility study. So the Corps could continue to maintain the property and act in a caretaker status, operating the Upper St. Anthony Falls for flood mitigation. They could look to a potential partner, so retaining that piece of their responsibility, but then look to a local partner to join in a feasibility study to look at what some options might be for a joint project if they're going to retain that share of their responsibility. A feasibility study would also require congressional action. That would be a two-step congressional action. One, there would have to be legislation authorizing a feasibility study. and then 2, a separate action appropriating funds for that feasibility study. And that study would require 50-50 local match with a local partner. The local project sponsor must be a public entity, and then there are some rules around that about how quickly they want to see that feasibility study completed. Now, again, this is the path that would be followed only if the federal government decided not to dispose of the property. Based on conversations that we've had with a lot of interested partners, it looks like they are probably going to move towards disposing of the property. We just don't know what that disposition is going to look like. Are they going to still want to retain that flood mitigation responsibility, dispose of it in its entirety? There are just a lot of unanswered questions about what the result of that study might look like. Indications are, though, that at the end there will be some action to dispose of all or significant components of the property. So that, Madam Chair, I would pause for a moment to see if there are any questions about that component, and then I would move on to just a couple notes about state geo bonding and how that might interact with this project.
I'm not seeing questions on this. Just, I guess the point is there's quite a bit of process left, and the exact length of the process is a little hard to determine, but maybe the most concrete thing is kind of this estimate around the disposition study, which then triggers the other formal actions that need to take place as well. And so I think, and I'm not sure kind of how your next, maybe this next piece addresses this, but I think that the question then is at least for right now, this is on our recommended bonding list. What is the implication to the city and any potential risk to the city of this if this remains on the list and it got an award?
Thank you, Madam Chair. And yes, that is what we're going to be touching on now. And just by way of refresher for the committee and for anyone watching, as Madam Chair noted, the redevelopment of the Upper St. Anthony Falls Lock is the number 4 priority on the city's bonding priority list. It's a request for $1.5 million for pre-design and design. And just a refresher, there are some fairly stringent constitutional and statutory requirements that are imposed on any award of GEO general obligation bonds. The constitutional requirements you see here are that a project must be owned by a public entity, and public entity being a state, county, or city. That public entity cannot be the federal government in order to receive state bonding awards. GEO bonds must be, and this is the real foundational pieces. There are a lot of other additional requirements, but these are kind of the big 4. They must be for a public purpose. The purpose must be specified in law and authorized in the Constitution, and mature in not more than 20 years. Those are the basic constitutional requirements for geo bonding. In addition to that, there are statutory requirements. Capital investment appropriations to political subdivisions, such as the city, are largely governed by one particular statute. And the big requirement also is that 50%, there must be a 50% match from non-state revenue sources should be matched with all capital investment awards to political subdivisions, with very few exceptions. And Madam Chair, to your question about the implications for the city, good rule of thumb is that once GEO, always GEO. And there's a specific quote that I wanted to note that's included in the State Capital Grants Manual, which is kind of the Bible if you have any specific questions about how to obtain and manage state GEO grants. And that particular note is, if pre-design and design grant is funded with state general obligation bonds, then the facility or property will become bond financed property, subject to all of the requirements of Minnesota Statute 16A 695, if and when the project is implemented, even if it is constructed with funds other than state general obligation bonds. Once a facility or property becomes bond financed, it will remain so for 125% of its useful life, or until such property is sold in accordance with Minnesota Statute 16A 695 and the Commissioner's order. The determination around these factors that you see noted here is made by Minnesota Management and Budget and the State Bond Council. It's nothing that the city really has kind of any influence or control over. That when these criteria are met is really the determination of those two respective parties. So, the quickest way to say it, and that we kind of use kind of back of the envelope, is that you can't be a little bit pregnant. If there's a little bit of GEO money in a project, then the entirety of the project is considered to be general obligation bond financed. Even if going forward, the remaining funds that are used on that project are non-GEO, the state still retains that constitutional and statutory requirement over the property. And so the implications for the city are, if GEO bonds are awarded for pre-design and design, the city would be agreeing to serve in the long-term ownership and sponsorship role for this or any other project. The project is subject to constitutional and statutory requirements of public GEO bond financing, regardless of how the remainder of the project is financed. And again, the terms of GEO bonds are determined and approved by the State Bond Council and Minnesota Management and Budget. And a cash grant award, not GEO bonds, would be less restrictive and leave the city with fewer future obligations. So with that, Madam Chair, I would turn it over to questions from the committee. That's the entirety of what we have to offer today.
Checking, I'm not seeing questions from committee members. Just double checking. And all right, thank you very much.
Thank you.
And then finally, we have space for federal, state, and local updates. Mr. Ranieri.
Madam Chair, a couple of things at the federal level. We received word this week that all of our HUD projects, programs, we have grant agreements for them. So we have a funding agreement for CDBG, ESG, Home, and I'm forgetting the fourth one. But all four of our programs that are part of the community development process have been funded and agreed to by the federal government. We have FY17 funds, we have some FY18 funds, and if there's a continuing resolution in December at the same level, we should have pretty close to full funding for those programs. But we'll wait and see, but at least we have been approved. The second one is just about 2 hours ago, the president declared a public health emergency for the opioid crisis. That could be for up to 90 days. He's asked the Department of Health and Human Services to come up with some concepts and ideas. However, there is no new money for this program now. He does allow for some flexibility in the programs now being used by state governments for healthcare and other things. You can maybe do some repurposing, but there's no new money for this crisis. We do know there's a lot of interest in Congress, but we have to wait and see. But it has been, and he did declare this 2 months ago, but now it's a public health emergency. The last item is the budget resolution was passed. It passed by just a few votes in the House, and that now allows for the foundation to do tax reform, and it would only require a 50% vote or 51% vote, 50 plus one vote in both bodies to pass, particularly in the Senate. So, and the resolution is not binding. Now, the budget resolution is more of a recommendation. So stay tuned. We may be seeing a lot of discussion about income tax and federal taxes within the next couple of weeks. Madam Chair, I'll stand for questions.
Council President Johnson.
Madam Chair, and thank you, Mr. Ranieri. Following up on, just what you see out there with this tax reform stuff, I mean, this idea of going after people's 401ks in the amount that they can contribute to 401ks, I think perhaps will affect, if they do that, more people than the state and local tax deduction, for taking that away, whether that happens again, or not. But I'm just wondering if it would make some sense for us to, seeing as how we've said something about the state and local tax deduction, that we might want to say something about not supporting any changes to the 401k rules. It just blows me away. They've taken everybody's pension away, and now that was supposed to, I was thinking back that I think during the last Bush administration, didn't they want to turn over the Social Security to everybody have to be 401ks? You know, I mean, it's unbelievable. So anyway, I think we should maybe think about that. That's all.
So maybe I'll just take that as, I don't know if we need to vote on it, but just a direction to staff to review what might be some language for our agenda. And I'm not seeing any objection from other council members here. So with that, anything else, Mr. Ranieri?
Madam Chair, no, not at this time.
Okay. All right. So with that, we have concluded with our business for today, and we are adjourned.